Good evening, everyone, and welcome to the Court of Appeals for tonight's lecture, Shakespeare and the Law. Just one bit of housekeeping at the beginning, and that is that at the conclusion of the lecture, please join us in the Lawyer's Lounge, which is to your left as you exit the courtroom, for light refreshments courtesy of the Historical Society of the Courts of the State of New York. Indeed, tonight would not be possible without the Society's sponsorship. We're therefore very pleased that our former colleague and my forever soulmate, Judge Albert M. Rosenblatt, the Historical Society's president, is attending tonight's lecture with his lovely wife, Julie. And also with us is the Historical Society's amazing executive director, Marilyn Marcus. We also want to extend thanks to Maggie Mancinelli Cahill, the artistic director of the Capitol Repertory Company, our neighbor just down the street, for her invaluable assistance in securing this evening's theatrical talent, Tim Dinahan and Stacy Lenartz, whose autobiographical information and credits you will find in the program. This now brings me to our speaker, Daniel J. Kornstein. Dan grew up in the Bronx, went to New York City Public Schools, CCNY, and Yale Law School. He was drafted in 1969 after his first year in law school and served in the Army's 1st Armored Division and the 1st Cavalry Division. Assigned as a legal clerk in a JAG office, he helped prosecute one of the My Lai massacre courts-martial. As a practicing lawyer, though, Dan has always been a civil litigator. He reminds me that he has argued 2 cases here in the Court of Appeals. He lost both times. So we're extremely happy, Dan, that you don't hold grudges. I asked Dan how he became interested enough in Shakespeare to author 2 books in the little spare time available to a busy civil litigator. He answered that beginning in high school, he had attended the free summertime performances of Shakespeare in Central Park. In 1985, after practicing for a little over a decade, he saw a production of Measure for Measure and was struck by its legal themes. This led to a short essay on the play for the New York Law Journal, which led to thinking about Shakespeare's legal themes in other plays, which led to more essays, more reading, and before long, he had expanded the essays into chapters and had authored 2 books. So one thing led to another and ultimately led to tonight. Please join me in welcoming our speaker, Dan Kornstein.
Thank you, Judge Reed, for that kind prologue. Prologue is the right word to use tonight. This is the perfect space for our topic. Why do I say that? Shakespeare and the Law is a subset of law and literature. One of the greatest judges of this great court once wrote a wonderful essay on law and literature. In that essay, Benjamin Cardozo referred to a love of art and letters as an amiable weakness. That was the phrase he used, amiable weakness. In that essay, Cardozo said that lawyers often show an amused or cynical indifference to literature. But, Cardozo pointed out, such indifference betrays a misconception of the true significance of literature. This evening, we indulge that amiable weakness, and it looks as if an awful lot of us have that amiable weakness, and we try to see, if only briefly, what significance Shakespeare, that giant of world literature, has for law. We think Judge Cardozo, looking down at us, would approve that we're talking about law and literature in his courtroom. Now, to try to talk about Shakespeare and the Law in 30, 35 minutes is a little bit like doing a history of the world in 15 pages. It's a difficult task, but we'll try. Most people don't realize how much law permeates Shakespeare's plays. It's extraordinary. 20 of the 38 plays have trial scenes. There are lots of comments about law and lawyers in the plays, very few of them complimentary. We all know the famous line, first thing we do, let's kill all the lawyers. We can debate whether he meant that as a serious criticism or whether, since it comes from a character named Dick the Butcher during a rebellion, whether Shakespeare was really saying the first thing you have to do in order to have a revolution, to get rid of stability in the rule of law, is to get rid of the lawyers, and it is a way of complementing what we do. So much knowledge of legal intricacies appears in the plays that over the centuries, a number of people, particularly eminent judges and lawyers, have come up with the notion that Shakespeare must have had legal training. Or they say the person who wrote the plays must have been a lawyer, not Shakespeare. Now that is what we call the authorship debate, and it's a rabbit hole that we don't have to go into tonight. It's, as I say, that's another story. But the movie last year, Anonymous, I don't know how many of you saw it, but it was about the suggestion that the Earl of Stratford was the real author, and it was quite controversial when it came out. It is one of those debates that never gets completely resolved, and that the people who believe Shakespeare was not the author are often very zealous in putting forth their views. But the truth is that Shakespeare helps us understand law, and law helps us understand Shakespeare. To some extent, we have to be wary that we don't simply use our own lens to find things. I suppose if someone is a feminist, you can read all the plays and find feminist comments. If someone is a Freudian, you can find all sorts of Freudian psychological comments. But the lawyer stuff is real. And that's not a surprise, really, because great art is often inspired by a passion for justice. We've seen that many, many times in the things that we read and we remember. With so much law in Shakespeare, we might even consider using Shakespeare as a means of teaching law. The poet William Carlos Williams once said that Shakespeare is the greatest university of all. Maybe we can try to paraphrase that and say that Shakespeare is the greatest law school of all. And that would mean that tonight, in a sense, we're having first-year orientation at the Shakespeare School of Law to see what the curriculum is like. We'll look at the course catalog for the Shakespeare School of Law and just see what we have. And again, no surprise that the literary figure most often cited by American judicial opinions is Shakespeare. And even in this court, I've found at least 9 opinions where the judges have cited him. None by any sitting judges now. I don't know what the reason for that is, but in fact, there are 2 types. Oh, I missed it.
You missed it.
Okay. Some of the citations are just decoration. They're not really legal citations, but others are to demonstrate and illustrate a particular legal point, often with great force. But to frame the issue, and we lawyers always like to frame the issue properly, let's start with a limerick that found its way into a United States Supreme Court opinion in 1989. It was a case about punitive damages, and Justice O'Connor had made some sort of a comment in a dissent quoting from Romeo and Juliet. Justice Blackmun, for the majority, dropped the footnote in response to Justice O'Connor. And here was the anonymous limerick that he put into the opinion. Though Shakespeare, of course, knew the law of his time, he was foremost a poet in search of a rhyme. Let's see if Shakespeare, foremost a poet in search of a rhyme, has anything to teach us about the law of our time. As we go through this imaginary course catalog, let's start with constitutional law. Certainly, we would agree that separation of powers is a fairly important legal topic. Why can't we think of Julius Caesar as a play about a struggle between the executive and the legislature. We have an imperial presidency, a unitary executive, and a certain form of Senate backstabbing. But that's not all. The question of sovereign immunity. In several of the plays, Macbeth, Lear, Richard II, either the sovereign or someone close to the sovereign doesn't understand how they can be brought to justice for anything. Who can pass judgment on the head of state? Now, we've had cases, the Nixon tapes case, Paula Jones against Bill Clinton, that involve similar issues. We can draw on these in terms of forming our own views. First Amendment freedom of religion. Remember in the trial scene in The Merchant of Venice how one of the cruel punishments that Portia imposes on Shylock is forcing him to convert. That certainly would raise issues of freedom of religion and establishment of religion if it were tried in any non-fictional country. Due process, basic principles of due process. In The Winter's Tale, the action turns on Hermione, the queen, insisting on a just and open trial. Well, that's certainly one of the essences of what we think about due process. And again, in The Merchant of Venice, that's pretty close to a trial by a mob, and we know from the Leo Frank case, and as it went up in our own court system, there are parallels. Equal protection. Remember the famous scene in King Lear when Edmund makes a speech, he calls it "Stand Up for Bastards," and he says, "Why bastard? Wherefore base?" That particular exchange has been quoted in several of the Supreme Court cases dealing with rights of illegitimates. And in one case, Levy against Louisiana, Justice Douglas wrote the majority opinion, quoted it. Justice Harlan disagreed with the reliance on it because he thought Edmund was such a despicable character, and therefore he was really base. But that had nothing to do with his parentage. In The Merchant of Venice, there is a statute that imposes greater punishments on aliens than on citizens. But in that case, that play, so you would confuse case and play, in that play, Shylock was not an alien in the sense that he was a foreigner. He was an alien because he was a different religion. Now we can even look at the sonnets to get a sense of what is perhaps the most basic debate in constitutional law, original intent versus a living document. Remember, many of the sonnets are from Shakespeare to his lover, whether it was a man or a woman, and he's saying that what he's writing will outlast the lover's youth and beauty. He talks about the miracle of black ink and how it will go on forever. Well, some people have argued that that is one of the arguments in favor of originalism, that that's the reason for having a written constitution, that it's put down on paper and continues. Now, who would have thought that you'd find that in the sonnets? Contracts, basic first-year course in law school. Wouldn't you think that a loan agreement that had an obnoxious penalty clause, let's say a pound of flesh, could be considered an example of a contract void as against public policy? Can you sever that clause from the rest of the contract, or is it something that you throw out the entire contract? Certainly, Merchant of Venice provides a good vehicle for illustrating that point. Criminal law, certainly one of the great mysteries of criminal law in history is whether Richard III really killed the little princess in the tower. Much debated, could use it as an example. Guilty conscience, Hamlet's use of the murder of Gonzago, the play within the play, in order to bring out Claudius's guilty conscience. Remember, Claudius runs out of the performance because he's so upset. crime of passion, Othello murdering the unfortunate Desdemona. Diminished mental capacity, again, perhaps Hamlet was temporarily insane, or was he putting on an antic disposition, as he says in the play? Antic disposition or a crazy act. Remember the case with Chin Gigante some years ago in New York, where one of the mafia dons was about to be sentenced, and he ran around Greenwich Village in his pajamas claiming he was crazy. When Ophelia dies, is she a victim of emotional battering from Hamlet? Or is it a case of a breakup that didn't work well? Should he be somehow criminally responsible for that? In criminal procedure, right of confrontation, two of the plays, King John and Richard II, talk about the right of confrontation and have been cited by this court as predecessors to the constitutional right, showing that the right of confrontation is just so basic it predates the Constitution. Defamation law. In Othello, there's the famous quote that appears in many libel cases: "Good name in man or woman is the immediate jewel of their souls." And another character says, "Reputation, reputation, reputation." You see it all the time. In Much Ado About Slander, we get an example of the per se categories of slander. Much Ado About Nothing. But it is about slander. And the per se categories in that one, and the one that traditionally you see in literature, is imputing unchastity to a woman. You see a bit of legal history there, how that has evolved. Today, for example, would accusing someone of being gay be an instance of slander per se, defamation, or does that suggest that there's something derogatory about that, and is that an appropriate thing? Have mores changed, and is libel an area where categories from 500 or 600 years ago don't necessarily hold up? Matrimonial law, taming of the shrew. Trust in the states. King Lear, was Lear in his right mind when he gave away everything? Did he have diminished capacity? And the law of inheritance generally, he gave everything and lived to regret it. War crimes, Henry V. Election law, Coriolanus. Maybe Citizens United has something to do with that. And this year in particular, given that it's a presidential election year, encourage everybody to reread Coriolanus, a very startling example of how democracy can have unfortunate consequences. Legal history. King John, it's an obscure play. People rarely read it. What do we know about King John other than being Robin Hood's adversary in league with the Sheriff of Nottingham? Mostly we think about Magna Carta. And here is Shakespeare in 1600, a lot closer to Magna Carta than we are. He writes a play about King John. Magna Carta is nowhere in the play. Gone. Not there. Why? Very important reason. Magna Carta did not emerge as the anchor, the bulwark of liberty that we think of it today until about 10 years after Shakespeare died, when the Stuarts were in conflict with Parliament and Lord Coke was pressing the case. He revived interest in Magna Carta, and then it became what we now think of it. So you see this almost historical growth that is not something that is necessarily obvious. In terms of legal philosophy, law versus emotion, reason versus passion, Hamlet, The Winter's Tale. Remember, in the bicentennial year, Justice Brennan gave a Cardozo lecture where he talked about that, reason, passion, and the progress of the law. And former Chief Judge Kaye wrote an article about that in the Cornell Law Review, that we do need feelings and emotion in the law, that it shouldn't be something that's disembodied. We can go to the skills, legal skills. What can we learn from the plays that would benefit a lawyer's legal skills? We can start with legal writing. one could do worse than read Shakespeare in order to improve one's writing. Oral advocacy. Compare, in Julius Caesar, Brutus's eulogy for Caesar, the funeral speech, with Mark Antony's funeral speech. Brutus gave a nice speech. It was very flowery. It was a good speech, and everybody said, yes, that's a good speech. Mark Antony gave a speech, and the people were ready to riot and go after the people who had assassinated Caesar. It's the difference between effective advocacy and just pretty words. A good lesson for lawyers to know. The importance of settlement. Remember in The Merchant of Venice, Shylock refuses 3 times the amount of money that he lost, and he regretted it. Moot courts. You could have moot courts based on the plays. That would be very effective teaching tools. Pro bono, a subject that has, in the last few weeks, gotten some attention up here. There's an exchange in King Lear where the fool says to King Lear something. Lear says, "That's nothing." And the fool says back to him, "'Tis like the breath of an unfeed lawyer. You gave me nothing for it." Translated to our modern vernacular, free advice is you get what you pay for. That doesn't mean pro bono is a bad idea. Or pro bono could be interpreted as involuntary pro bono, those clients who don't pay their bills. Now, Hamlet, with all his talking and indecision, could be an example of lawyerly traits in action, much like perhaps Felix Frankfurter in Judicial Restraint. But then we come to one play that could really be a seminar all by itself for a law school curriculum, and that's Measure for Measure. We're impressed and amazed with all the law that we've seen in the plays, but Measure for Measure is this extraordinary play about law and morality with lots of issues, and in fact, it is really a dramatic prism that refracts and splits the white light of the play into a rainbow of legal issues. Those issues were controversial 400 years ago. They're still controversial today, and perhaps even more so, as we'll see. The storyline in Measure for Measure sets up the legal themes from the start. The Duke of Vienna is worried that his subjects have no respect for laws because the Duke has not been enforcing them. He pretends to leave the city. He appoints Angelo, a supposed straight arrow, as the acting Duke in his absence. The result is a resurgence of law and order, very rigid, and a collapse of mercy-tempered justice. Angelo starts to enforce the laws that the Duke did not. One of those laws imposed a mandatory death penalty for sex outside of marriage. It had not been enforced for 14 years. Angelo invokes this harsh law against a young man named Claudio who made his girlfriend Giulietta pregnant. Claudio's sister, Isabella, pleads with Angelo not to execute her brother. Angelo, before now assumed to be a paragon of virtue, tells Isabella he will spare her brother's life, but only if she will have sex with him, Angelo. The rest of the play revolves around this basic conflict. This is how it happens.
I think and pray to several subjects. Heaven hath my empty words. Lost my invention, hearing not my tongue, anchors on Isabel. Heaven in my mouth as if I did but chew his name. And in my heart the strong and swelling evil of my conception. The state whereon I study is like a good thing being often read, from fear and tedious. Yet my gravity, wherein, let no man hear me, I take pride. But I would boot change for an idle plume, which the air beats for vain, of place, of form. How often dost thou with thy taste, thy habit, wrench awe from fools, and tie the wiser souls to thy false seeing? Blood. Thou art blood. That's right, good angel on the devil's phone. It is not devil's rest. How now, who goes there?
I am come to know your pleasure.
That you might know that it would have you much greater pleasure than to ask it answer. How now, fair maid? Your brother cannot live.
Use. Heaven keep your honor.
Yet may he live a while. And it may be as long as you or I. Yet he must die.
Under your sentence.
Yet.
Grant, I beseech you, that in his reprieve, longer or shorter, he may be so fitted that his soul sicken not.
Why are you still devices? It were as good to pardon him that hath from nature so a man already made, as to remit their saucy sweetness that do coin heaven's images, thanks to their own forbidden. 'Tis all as easy, falsely, to take away like true men, as to put metal in restrained beings to make it false.
'Tis set down so in heaven, but not in earth.
Saint, I suppose it perfect. Which have you rather? That the most just law now took your brother's life, or to redeem him, give up your body to such saucy sweetness as she that he hath stained?
Sir, believe this. I had rather give my body than my soul.
I thought not of your soul. Our compelled sins stand more for number than for a count.
What say you?
Nay, I'm not going with that, for I can speak against the thing I say. Answer to this. I, now the voice of recorded law, pronounce a sentence on your brother's life. Might there be charity in sin to save this brother's life?
Please you to do it. I'll take it as a peril to my soul. It is no sin at all, but charity.
Please you to do it, that peril to your soul. For equal measure of sin and charity.
Then I do beg his life, if it be sin. Heaven let me bear it. You grant it of my suit. If it be sin, I'll make it my morn prayer, to have it added to the faults of mine, and nothing of your answer.
Nay, forgive me, your sense pursues not mine. Having your ignorance, or you hear so craftily, and that's not good.
Let me be ignorant, and in nothing good, but pursue his own and better.
Thus wisdom wishes to appear most brightly but taxes up, as these black masks proclaim and shield beauty 10 times louder than beauty could reveal. But mark me. If you speak plain, I'll speak more gross. Your brother must die. And his sentence is so that it stands accountant to the law upon that pain.
True.
Admit no other way to save it, as I subscribe that not that nor any other, but in loss of question. That you, his sister, finding yourself desired of such a person whose credit with the judge or own great place could catch your brother in the mantles of the all-binding law, and that there were no earthly means to save him, but that either you must lay down the treasures of your body to this supposed, or he must suffer.
as much for my poor brother as myself. That is, were I under the terms of death, the impression of keen whips I wear as rubies, and strip myself to death as to a bed that longing have been sick for, ere I yield my body up to shame.
Then your brother must die.
And tore the sheep away. Better it were a brother died at once than that his sister, by redeeming him, should die forever.
Were not you then as cruel as this sentence you have abated so?
Ignominy and ransom and free pardon are of two houses. Lawful mercy is nothing kin to foul redemption.
You have of late made the law attack, and rather prove this sliding of your brother a merit than a vice.
Oh. Pardon me, my lord. It oft falls out. To have what we would have to speak of what we mean. I something to excuse the thing I hate. For his advantage that I dearly love.
We are all afraid.
Else let my brother die. If not a federally, but only he should always succeed my weakness.
Nay, women are afraid too.
Aye, as the glasses where they view themselves, which are as easy broke as they make forms. Women help heaven, men their creation mar and property mine. Nay, call us 10 times frail, but we are soft as our confessions are, and credulous to false praise.
I think it well. And from this testimony of your sex, since I suppose we are made to be no stronger than bolts may shake our frames, let me be bold. I do arrest your words. Be that you are. That is a woman. If you be more, you're not. If you be one, as you are well expressed by all external words, show it now by putting on the destined liver.
I have one tongue, gentle. Let me entreat you speak the former language.
Plain to conceive, I love you.
My brother did love Juliet, and yet you say he shall die for us.
You shall not, Isabella, if you give me love.
More than virtue had a license in it, which seems a little fouler than it is to pluck on others.
Upon my honor, my words express my purpose.
Ah, little honors we must believe, and most pernicious purpose. Semen. Semen. I will proclaim thee, Angela, look for it. Sign me a present pardon for my brother, or with an outstretched throat I'll tell the world aloud what man thou art.
Who will believe thee, Isabella? My unsoiled name, the austereness of my life, my vouch against yours, and my place to stay shall so your argument overweigh that you shall stifle in your calumny and smell it. I have begun. And now I give my sensual grace the rein. Fit your consent to my sharp appetite. Lay my own niceties and delicious blushes which banish what they stew for. Redeem your brother by yielding up your body to my will, or else he shall not only die of death, but your unkindness shall his death draw out the lingering silence. Now to me tomorrow. And by this affection which my God me most, I will prove tyrant to you. As for you, say what you can. Mine also makes you free.
To whom should I complain? Did I tell this who would believe me? Oh, perilous mouths that bear in them one and the self-same tongue, either a condemnation or a proof. Bidding the law make getting along to the appetite to follow as it draws. Up to my brother, though he hath fallen by the pressure of the blood, yet hath he in him a mind so noble, that had he 20 heads to tender down, and 20 bloody blocks he'd yield him up before his sister should provide to such a horrid pollution. Then Isabella been chased, and brother died. More than our brother is unchastity. I'll tell him yet of Angela's request, and fit his mind to death, for his soul's best.
Isn't that great? Measure for Measure raises a host of basic legal issues. Let's start with sexual harassment. Every time the play is put on, when that scene is played, the audience reacts. You hear snickers, you hear audible reaction because it strikes a responsive chord. Whether it's memories of the Clarence Thomas confirmation hearings or just experience handling cases, one feels Isabella's pain. One gets the sense that it's real, and it's a real legal issue, a classic quid pro quo sexual harassment situation. Redeem thy brother by yielding up thy body to my will. And then when she says, I'll complain with outstretched throat, who will believe you? And then she says to herself, who will believe me? A very common reaction in that situation. Now, one way to think about the play is to think of it in terms of Bowers versus Hardwick and Lawrence versus Texas. Remember Bowers? That was the case. Supreme Court in 1986 upheld a crime of private homosexual conduct, upheld a 20-year sentence for a single act, although there's now some controversy whether anything even happened, and the law that they were operating under had not been enforced for decades. Think about that in terms of what the action in Measure for Measure is about, and then remember Lawrence v. Texas overruled Bowers in 2003. Think of Bowers, the Supreme Court majority, as representing Angelo's view of the law, and Lawrence representing the Duke, Shakespeare, and Aeschylus, another character and advisor to the Duke in the play. The basic question is, how much should law be used to enforce morals? It's a question that's been debated since the beginning of time. If conduct is immoral, should it be illegal? Should abstract morals translate into law? In Bowers, the majority said law is constantly based on notions of morality. No less a jurist than Oliver Wendell Holmes said, the first requirement of a sound body of law is that it should correspond with the actual feelings and demands of the community, whether right or wrong. But is moral outrage too subjective and amorphous and too threatening to individual liberty? Or is it a question of mores changing and how much the law should be used to accomplish those things? These are deep questions of legal philosophy. There's also the question of privacy. This is private sexual conduct between consenting adults. I'm not talking about Angelo and Isabella, but the law that was being enforced against Claudio because he got his fiancée pregnant. There's also the question of public respect for law. Remember, the reason the Duke leaves town to put everybody to the test is because he didn't think the public had respect for laws. The phrase was, the law is more mocked than feared. Liberty plucks justice by the nose. and the people's attitudes had made a scarecrow of the law. Angelo puts teeth into the law. Deterrence may arise, but is Angelo's version of the law a way to get public respect for law? Again, these are things that don't have easy answers, but the play brings them out. The play also brings out the question of dead letter statutes. In the play, the law had not been enforced for 14 years, and in Bowers, remember, decades it hadn't been enforced. The best discussion of this concept of dead letter laws was in book The Least Dangerous Branch by legal scholar Alexander Bickel. Around 1960 he came out with it. His notion was it's called desuetude. It's a Latin based word that means when the laws are not enforced for a long time, they've been nullified by lack of practice, and while they may be difficult to repeal, they should only stay on the books as symbolic, maybe aspirations, but not something that should be just trotted out because the potential for arbitrary enforcement is too great. Again, because we have a mandatory death penalty in the play, we have all the issues about capital punishment, Eighth Amendment, cruel and unusual punishment, severe punishment for minor infractions. And we see a rebellion on our part to the lack of correspondence between the offense and the crime. Sort of lends itself to a discussion of sentencing guidelines. Remember, in the federal courts, there was almost a revolt by a lot of the federal judges saying that the guidelines were too strict. And even today, in the modified form, there are complaints about that. How much discretion should a sentencing judge have? And does the play talk about that in any way? Mercy. When we think of mercy in Shakespeare, automatically we think of Portia's great quality of mercy speech in Merchant of Venice. Quality of mercy is not strained, it falls from like rain from heaven. Isabella has a better mercy speech in Measure for Measure. She has a much more important speech. It's less famous, but it talks about the issues that are really in that kind of a debate. Another aspect of Measure for Measure, at the end, when the Duke finds out about everything and he's going to punish Angelo for his corrupt judging, his misbehavior, Isabella defends him. And Isabella's argument is that, well, he never did sleep with her. What they do one of these bedroom tricks in Shakespeare so that Angelo thinks he's going to sleep with Isabella. Instead, he sleeps with his old girlfriend, and they get together again. So Isabella is pleading for Angelo's life, and she says, his acts did not overtake his bad intent and must be buried as an intent that perished by the way. Thoughts are no subjects, intents but merely thoughts. Here we have the criminal law doctrine of you need a criminal act as well as a mens rea, and there was no criminal act. Now, that particular interchange was actually quoted and cited by Justice Rehnquist in the Supreme Court opinion. So these things have real-world impact. Abuse of power. One of the greatest lines in Measure for Measure is about abuse of power. Isabella says, "Oh, it is excellent to have a giant's strength, but it is tyrannous to use it as a giant." Some of us might think it should go up right next to "In God We Trust" above the bench in every courtroom, and certainly everyone in authority should recite these lines before going to sleep every night. It's the potential for power that could be misused. But most of all, in Measure for Measure and in Merchant of Venice, you see two competing theories of legal interpretation. On the one hand, you have law in its strictest sense. On the other hand, you have discretion. Angelo stands for law, rules, logic, rigid enforcement, maximum penalty, the letter of the law, that it's not the individual judge who does anything, it's the law that condemns the wrongdoer, and the judge merely enforces it. The Duke, Shakespeare, and Aeschylus, another character in the play, take the other attitude, that law must be softened by realism, politics, equity, mercy, justice, discretion, flexibility, and the spirit of the law. So you see, in this play, these different themes. And then we get to the art of judging. Aeschylus, this character, talks about law should be meted out according to the nature of our people, our city's institutions, and the terms for common justice. Again, that's that more subtle approach to law. But we have crooked judges. Angelo is an example of a crooked judge. He's a corrupt judge, and he's not the only one in Shakespeare. Portia gets a lot of praise. Everything Portia's this great character in Merchant of Venice. She was a corrupt judge, if she was even a judge at all. Remember, she's a faker. But what happens, she's the fiancée of Bassanio, who was the reason why Antonio borrowed the money from Shylock. Does Portia tell anybody about that when she's rendering judgment? She should be reported to the disciplinary committee. Now, these are just some of the legal issues in Measure for Measure, and it's truly amazing. Who knew? And what it really means is that all of us should reread Shakespeare from time to time, because when we read it, most of us were in our teens or early 20s, or in high school or college. We read a few of the plays, and we just hadn't lived long enough to feel what's going on there. We could perhaps parrot the action, but you didn't know, you didn't understand the human emotions. And as we become lawyers and have practiced and judged for a while, you see things in the plays that you didn't see when you were younger. The plays haven't changed, but we've changed, and these are not things for kids. These are things for us. So when all is said and done, and after seeing how much law there is in Shakespeare, we might well ask of Shakespeare what Hamlet asks in the graveyard scene. This is what Hamlet says. Why might not that be the skull of a lawyer? So we end this brief, brisk tour of the Shakespeare School of Law curriculum by returning to our friend Judge Cardozo. In 1930, Cardozo spoke at the dedication of the New York County Lawyers Association building in Manhattan, and he quoted a passage from The Taming of the Shrew. It is as apt here and now as it was then and there, especially as we are about to enjoy a nice reception. The quotation from The Taming of the Shrew is also about another amiable weakness. These are the Bard's lines quoted in 1930 by Judge Cardozo. Please ye may contrive this afternoon and do as adversaries do at law. Strive mightily, but eat and drink as friends. Thank you.
Questions?
Yes, before the reception, questions. Oh, come on.
Send everybody into silence? I don't believe it.
Well, let's go in a different direction then. How many people think Shakespeare wrote Shakespeare? How many people think someone else wrote Shakespeare? No.
Amazing. Well, thank you again, and thanks again to Stacy and Tim for that wonderful